Welcome back to Quick Bits for October 14th, 2024. There have been some new trial dates set, a trial that was supposed to be starting that got bumped, and a very surprising plea deal rejected by Sarah Boone, plus updates in the Girardi case, the Baldwin case, and of course, there's always stuff going on with Diddy. Let's get into it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. First up, Sarah Boone was supposed to be starting trial in Florida October 7th, but due to Hurricane Milton, her trial got delayed by a week. So jury selection will be starting today, October 14th. Because of the hurricane, courts were closed. They didn't want to start jury selection. And the last day they were in court, which was October 7th, the prosecution offered and formalized a plea deal on the record, which Sarah Boone rejected. That plea deal would have given her 15 years, but she has been in since 2020. So over 4 years without any added time. So even with 85%, she would have been well over 5 years served and then would be serving 85% of that 15, but she rejected it. Let's take a look at how that went down in court last week.
Do you understand that if we were to proceed to trial in this matter, and if you were found guilty, the lowest permissible sentence that the court could levy in this case would be 22.5 years in the Department of Corrections? Do you understand that?
That is the court advising Sarah Boone that if she is convicted, the mandatory minimum sentence is 22 and a half years on the charge she is currently charged with, murder in the second degree. The prosecution was offering her a reduced charge and a 15-year sentence. Could a jury still convict her of a reduced charge? It's possible because it's going to be a lesser included, but I think after seeing that video, it's going to be an uphill battle for her. And for those of you new to this case, Sarah Boone is accused of killing her boyfriend by zipping him into a suitcase and leaving him there. There is video that was recovered from her phone of him telling her that he could not breathe, begging her to remove him from the suitcase, and her laughing at him and taunting him. She told police that she went upstairs and went to bed the next afternoon, came back down, and he was nowhere to be found, and she found him still in that suitcase. She said it's an accident at the time. Her attorneys are going to be arguing that this was an act of self-defense, but we will see how that plays out in court. The prosecution has made some motions to keep that out until she testifies that self-defense was necessary, which will be difficult because it contradicts all of the interviews she gave to law enforcement. Let's get back to court.
Do you understand the state's offer to resolve this case?
Yes.
And she said, yes, it's hard to hear. And this is the attorneys putting the official offer from the state on the record.
15 years to a lesser included charge of manslaughter, with the understanding that she would serve 85% of that sentence.
So it is hard to hear. The audio in this courtroom has been incredibly difficult, but 15 years to a lesser included charge, so a manslaughter, with the understanding that it would be served at 85% time.
That's up to the department and her behavior, but that is my understanding.
And the prosecution said it's up to the Department of Corrections if it's served at 85% or not. But
ma'am, understanding the state's offer, do you wish to accept or reject the state's offer to resolve this case?
Reject.
And the court asked her, do you wish to accept or reject the offer? And she very quickly said, reject. So this case will be starting trial with jury selection. It will be streamed. I will be streaming it. It should last several weeks down in Florida. We will see what the defense is able to get into after the court rulings, and we will see if it gets underway as it should, or if there will be additional delays. She was arrested in February of 2020, has gone through 9 lawyers now, well, is on lawyer number 9. So it has been a long road to get to trial in this case. But her rejecting that plea offer is probably going to be something she's thinking twice about, though at the end of the day, the difference between 15 years and 22 years might not seem that great to her if she wants to see what a jury might do, or thinks that she can convince a jury that this was just all an accident. And speaking of trials that are going to take much longer than just a few weeks, The court has set a new date in the Bryan Kohberger prosecution. That is the quadruple homicide out of the University of Idaho. The case recently was moved to Boise on a motion for change of venue, and the court granted that motion. So we are before a new judge with a new trial date, new motion dates, new procedures, and a new judge who is not going to put up with any nonsense in court, and laid that down pretty quickly in the last court hearing. The trial date is now set to start on August 11th. Let's take a real quick look at some of those dates that the new judge has set. And I'm happy that we're able to do it here on Quick Bits, because some of these things I'm just not going to be able to cover while I am covering trial. So if you want to stay in the loop with all of the cases, you want to be subscribed to Quick Bits and the Emily D. Baker channel or the Law Nerd app, because it will keep you in the loop to make sure that you're not missing the case updates on the case you might be following, even if you're not following along with live trial. The court's new scheduling order vacated all the other dates that were set. There were a lot of dates for motion hearings and things like that, and set the jury trial, saying that voir dire, the questioning of jurors, will begin July 30th, 2025 at 9 a.m. The trial will start August 11th, 2025, and run through November 7th, 2025. The judge is anticipating that that will include a penalty phase if necessary. Because this is a death penalty case, there is a guilt phase where it's determined by a jury if they believe Bryan Kohberger committed these murders or not. If they believe that he did and he is convicted, then it goes to the penalty phase, which will be what is the punishment. The court has indicated that trial will begin each day at 8:30, conclude each day at 3:30, with a 45-minute lunch break Monday through Friday, and there may be some scheduling issues. The court indicated a final pretrial conference will be held in May of 2025. Looks like May of 2025 is going to be real busy. And that they will set other dates as requested. And then there are a ton of motions that will need to be heard, including motions in limine, discovery motions, and the death penalty motions. They also listed when all the experts needed to be disclosed, which is normal in every case. So the court has laid out what the attorneys need to do between now and trial, and has also had an additional hearing that was not public and was ex parte regarding the changeovers in how the public defender's office is working. The court ordered that the current appointed attorneys for Kohberger stay on the case, and it seems that they are still trying to figure out what the new contracts will look like for defense attorneys in Idaho now that they went from a county by county public defender system to a statewide public defender system. And we need to talk about Diddy's trial date, Alec Baldwin, and a surprise in the Tom Girardi case after a thank you to our sponsor for this episode. Thank you to today's sponsor, Lume. Look, we all sweat. What we don't want to do is smell. And Lume's new whole body deodorant spray has you handled from your pits to your parts to the bottom of your feet. Yes, it works on the feet. Yes, I've used it on the feet. Emily, stop saying feet. But Lume's new whole body deodorant spray has the 72-hour odor control that you know and love in a whole new way to apply it. What I love is that their canister is designed for effortless 360-degree spraying, which means you can turn it upside down to get it onto your feet or those other hard to reach places. And because Lume uses a pH optimized technology, it doesn't just cover up odor with fragrance, it stops odor before it starts. Look, the starter pack is perfect for new customers. It comes with a solid stick deodorant and a cream tube, plus 2 products of your choice like the body wash or the really convenient deodorant wipes, and free shipping. But as a special offer for all listeners, new customers get 15% off all products, no matter what you choose. So if you want to maximize your savings with our exclusive code, you can combine the discount on the starter pack and the 15% off to equal over 40% off of your starter pack. Just use code EDBQB to get 15% off your first purchase at lumedeodorant.com. That's code EDBQB at LUMEDEODORANT.com. Let's get back to today's Quick Bits. So in the Baldwin case, Kerri Morrissey is still asking the court to reconsider her dismissal of the case on the defense's motion regarding those Troy Teskey rounds, and the court's finding that that was Brady information that needed to be turned over to the defense. And because of the time it was disclosed, that the only proper remedy was to dismiss the case while it was in trial with prejudice. I don't know what law Kerri Morrissey is relying on. She hasn't cited any to allow her to do this or to allow the trial court to undo a dismissal with prejudice in a criminal case. But that's what she's asking for. And she is asking the court to set a 2-hour hearing for her to continue to argue this. But she's not done because she also filed her reply, 70 pages with attachments. Kerri Morrissey has been enjoying pushing the page limits in this court. And I think that is probably pushing Judge Summer a little too far. But she definitely took the opportunity to take a few shots at the defense attorneys, which are rich given everything that's happened in this case. Looking at this motion briefly, she says the state is asking the court to review the facts and evidence before the court, not the false narrative being put forth by the defense intended to vilify undersigned counsel and the state's witnesses. Ma'am. She also said that the defense knew about the Teskey rounds prior to trial, but argued the contrary to the court. It doesn't matter, though. She also said, based on the defendant's misrepresentations to the court on July 12th, the court issued an order that relies heavily on the supposition that the defendant was unaware that the Teskey rounds were in evidence and that 3 of the 23 rounds had the same characteristics as the live rounds found on the set of Rust. Dude, that's not what happened. That's just not what we saw play out in trial. It is the obligation of the state to turn those over. And the state didn't do that. And then the prosecutor asked the witness on the stand, were any of those similar to the ones on the set? And she said no. And then they brought all those rounds into court, and the court got down there with her gloves on in her robe and saw the rounds for herself, and 3 of them were the same. Had this been turned over, there would have been vigorous cross-examination about where those rounds came from. But because it wasn't disclosed, because it was under another case number, then it becomes a problem for the prosecution. And she is still trying to dig out of this hole, and it is not going to work. She goes on to say that the court's entire analysis surrounds a Brady violation that was discovered during trial. The fact that the defendant failed to address this issue in the slightest in his response speaks volumes about the misrepresentations made by defense counsel during arguments to the court on July 12th. The state raised this critical issue with the court on July 12th during arguments in opposition to the defendant's request for dismissal, and the court agreed that the defendant's knowledge of the ammunition prior to trial was relevant to prejudice. I don't think the defense knew what those rounds were. But even if they did, it's the obligation of the prosecution to turn them over. So while Kerri Morrissey continues to fight on this point, I don't think she's going to be successful here. But I am very interested to see what goes down in this hearing and how this argument goes between her and Spiro. Remember, Spiro is asking for the fees that it cost for the defense to defend against this motion brought by the prosecution. And that's really what I'm curious to see. Will the court grant attorney's fees here? Because there's no basis in law to even bring this motion. And apparently disgraced lawyer Tom Girardi's CFO thought that there was some basis in law for a conviction because he just pled guilty in the case that Tom Girardi went to trial for earlier this year and will be sentenced in December for. And I think we will see this bring a close to most of the Girardi prosecutions. Christopher Kamon, the CFO of defunct law firm Girardi Keese, pled guilty to 2 counts per a plea agreement with the government. He has not been sentenced yet. They will be doing a sentencing report. But interestingly enough, he did agree to a forfeiture of over $3.1 million. He faces a maximum of 40 years in this case, but the government said that they would be arguing for the low end of the sentencing guideline range. So once that pre-sentencing report is completed, then the government will file their sentencing memo, the defense will file theirs, and we will see what the judge does as we saw in the case of Alec Murdaugh with his federal sentence, the federal judge does not have to rely on what is argued by the government. And in Murdaugh's case, we actually saw the judge saying, I know this is what you're asking for, but I think more, and going above the range that the prosecution had asked for. So what will happen when it comes to Christopher Kamon? We will see. But I'm interested to see if that sentencing will end up getting set over till after Girardi's sentencing or before. Remember, Girardi will be sentenced at the beginning of December, so these could actually take place close in time. That would be enough time to get a pre-sentencing report and the sentencing memorandums done. So maybe these will both end up happening in December. And we got to talk about Diddy because the 2025 trial calendar is getting real full. Diddy was back in court before the judge that his trial will be held in front of last week. The trial court set the trial date for May 5th, 2024 to start jury selection, but Diddy still has an appeal pending for his bail. He's filed some things under seal. His initial motion wasn't under seal, again, arguing that the prosecution hasn't met their burden to keep him in custody. But remember, on the charges he is facing, the presumption is no bail. So it really does shift to him to show why bail is appropriate because of the presumption based on the statute. On October 10th, the Court of Appeals filed their decision with regard to Sean Combs' immediate release while appeal was pending and denied that request. They were disinclined to let him out pending appeal. They also ordered that the motion for bail will be heard by a 3-judge panel and that the motion to seal the defendant's argument was granted. So most of what the defense has argued is filed under seal. We will see that the prosecution response will therefore also be under seal. A lot of the appeals court arguments you can hear on an audio feed. So it will be interesting if this audio feed is allowed, even though some of the motions are under seal. But we've also seen the defense ask for a hearing early November. So if the Court of Appeals moves that quickly, we might see a hearing on this as soon as early November. I'm interested to see what they're going to argue. It's going to be more of the same as what we saw in the district court. So it's not going to be much different. And the burden, again, is on the defense here because of the statute. So it's unlikely that Diddy would be released. It would be more extraordinary if he were. This is not an appeal I expect him to win, but they are continuing to refine their arguments to get him bailed out. And it seems that that's very much something he wants. Interestingly enough, when the defense was last in court, they also asked for a gag order in this case and had argued that the feds with DHS had leaked that video from the Intercontinental Hotel in Los Angeles with regard to the Diddy assault of Cassie, arguing that that had been leaked by government agents and that it was unfavorable and improper pretrial publicity. The prosecution struck back and said nobody on the government team leaked that. CNN obtained it, and that was the first time they ended up seeing that video, was after CNN obtained it. So it will be interesting to see how this goes and to see if, like in other cases, the defense tries to pull the media in and find out where they got that from, though CNN's going to be largely protected by their privilege as journalists to not have to disclose that source. And even when it goes to trial, the government will be able to authenticate that through employees at the hotel, though not necessarily revealing where it came from, which could be something the defense will fight on down the road is, well, did you turn this over? Are you the one who downloaded this video off of the security system? So authentication might be an argument very far down the road. But for now, a trial date set May 5th. Do I think that will remain the trial date? No, I don't. The prosecution's already been talking about the terabytes of data that they are pulling off of over 96 digital devices. I don't see how the defense will have time to adequately prepare to review all of that digital information. But I think at this point, they're hoping to jam up the feds to make sure that they are working at warp speed, going through everything and hoping to maybe limit what they find in the time that they have to review all that digital evidence. But The resources of the federal government are vast, and they are going to be able to put as many people as they need on this case to look at all of that digital evidence. Plus, if there is a superseding indictment, which is always a possibility, then it's going to push this case back. So I wouldn't write this one down in pen just yet. I think this case is going to end up getting pushed out a bit more before we see it go to trial. But will we see the court grant a gag order in this case? I'm really interested to see what this judge chooses to do. And yes, there is lots more going on in the law, and I will hopefully get to it in next week's Quick Bits. If you're interested in following along with me for Gavel to Gavel live trial coverage, that will be over on my YouTube channel, The Emily D. Baker, or you can download the Law Nerd app to stay in the loop. And hopefully this Quick Bits is helping you stay in the loop with the cases that you want to know about. I will talk to you in the Quick Bits again soon, and I look forward to hearing this very soon.
Bring the jury.
Because you know how much I love live trial coverage. Thanks for being here. Thanks for being a Law Nerd. I'll see you in the next one. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.